Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial, and the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along thrown A, and the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty, so yeah, I was completely dumbfounded. I'm still a law student and this happened during my first internship at a court. A girl among other people was charged with drug possession, but because she had thrown away the drugs and the police couldn't prove that she bought or owned the drugs, BC it could have been one of the other people as well who still had drugs on them. The judge ruled in dubio pro reo. He then asked if she wants to add something and this girl asked if she can get her drugs back. The defense attorney looked like he was about to get a heart attack. Edit. For those wondering, I know what in dubio pro reo means, but I wasn't sure if they use the term in other countries and tried to explain it if not. This happened in Germany. Not a lawyer yet, but I clerked for a DA's office throughout law school. Obviously we don't have clients, but I'll never forget this kidnapping case I worked on. It involved two Asian male defendants who were both the same age and looked relatively similar. Witness is on the stand and is asked to identify where the defendant who pushed an Uzi into his face is seated. It's clear the witnesses is having trouble differentiating the defendants. A true moment of brilliance. One defendant raises his duck-eyeing hand and basically points to himself like, right here bud. Hands down the dumbest tip I'd ever seen. I thought his defense attorney was going to have a brain aneurysm. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. A friend of mine is a lawyer and he said that a client once turned up to court in the actual same outfit he was wearing in the burglary. When the CCTV footage come up in evidence, the client looked down to himself and was like, "Ooh it." Edit. My first ever awards. Cheers. Unfair dismissal case. The client claimed to have been dismissed without reason or following procedure. After we had started the case, it comes out that not only was he given 3 written warnings, but he was also called in for a disciplinary hearing before his dismissal. Don't lie to your lawyer. Had a woman with an expensive fur coat and she claimed that the laundry ruined it. It was kinda ruined, but the laundry claimed those stains were already there. Judge ordered an expert opinion, lab, and the fur coat had traces of sugar and other illegal drugs all over it. There was a raid at her place then and her husband got convicted because they found several kg of drugs. A defendant was written a cell phone ticket while driving and defended himself. Your Honor, I was not using a smartphone while driving. I was actually using a flip phone. Guilty. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason, he organized via Craigslist to have someone collect a box of his cum from a children's playground. There were explicit messages from him asking what they did with it, and whether they rubbed it all over themselves. The employer provided us the messages. Edit. He was doing this on company time. Not a lawyer, law student, and not exactly what you asked for, but I feel like it fits here anyways. We read about a criminal case in which there wasn't enough evidence to convict the suspect. So the suspect was not guilty due to reasonable doubt. And he responded, "Thank you, judge. I'll never do it again." DA went into appeal and dude got convicted. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. Case as a paralegal. Negligence case. Client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Not me, but my dad represented a guy in a civil case. He doesn't normally do criminal law, but in this instance the question of a forged signature came up, and his client lied, saying he didn't forge it. My dad was very clear in explaining that admitting to him wouldn't land him in jail. It would just allow him to build a better defense. But he still denied forgery, and so my dad rolled with it. He said his case was completely cut up once it came out that yes, in fact, his client did forge the signature. Guys and gals, your lawyers aren't a snitch. They're trying to get you the best possible result. Always be honest to your lawyer. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault. I never touched her. I just threw an AC at her." This is bullet. Judge rescinded plea deal because of defendant's attitude, lack of remorse. Went to trial and got a year in jail. This one ended my marriage. Well, it was the start of the end of marriage. My husband lost his job in the title mortgage business. Applied for unemployment. Got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, is there anything you did that caused them fire you? He says no, absolutely not. They fired him out of nowhere. Hearing day comes. He testifies under oath that he did nothing wrong. Was a good employee. No issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings. Documents he forged and backdated. Had to admit he perjured himself. Needless to say, he didn't get unemployment and he didn't sleep at home that night. UK. Not a lawyer as such, but a planning consultant. Client signed sworn affidavit stating he'd been running a truck park business for over 10 years on a piece of land. After 10 years the use becomes immune from legal action. The counsel checked Google Maps and saw immediately he lied. Had only ran the business for 7 years. He had committed a criminal offense by submitting a false sworn affidavit. Plonker. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. I was involved in a hit and run car accident. My leg was pretty mangled. However, the driver of the car was caught. Turns out he was a rich kid who was driving his mum's convertible Porsche. Denied all knowledge of hitting me, etc. At the trial, the prosecutor asked him how long he had been driving, to which he answered, "Do you mean how long have I been driving legally or illegally?" The judge then went nuts asking why and when he had been driving illegally. His defense team sat down in their chairs and shook their heads. Needless to say, he lost the case. Interestingly, he died a year later by drowning. He had hired a speedboat and holiday, flipped it over and drowned. Turns out he was drunk at the time. Karma can be a cunt. Not a lawyer. My parents had a long messy divorce that took 2.5 years in court. My dad claimed that my mother was trying to take 100% of everything based on a settlement offer she sent him. He failed to mention to his lawyers that her initial offer, also sent to his previous lawyers, was a 60/40 split, and she only sent that 100% one in response to an equally unreasonable offer from him. As soon as she could prove the initial offer was reasonable, the judge just basically ruled on everything according to that first offer. His lawyers were so angry because they built their entire case around the idea that she was the unreasonable one. I think it was something to do with arguing that she was not sending genuine settlement offers. I'm not sure why. His goal wasn't to win. It was to prolong the battle. But the original offer exposed him in the lie in front of the judge, which made the rest of the process go very quickly. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table and she is bending over trying to reach it from her chair, but pen was too far away. So she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay and her response was that she was fine. Her attorney leaned over and said something to her and she then loudly started complaining about her back and how much her back hurt, but no one believed her. Lol. Not me, but my legal studies teacher, who used to be a lawyer, was representing a woman suing a supermarket for a slip that caused her to hurt her shoulder. She had to tell the court how much it had impacted life and the fact that she couldn't do her everyday tasks. She said, "I can't even lift my arms like this to hang the washing," and proceeded to show the court the exact gesture in perfect form that she was explaining she also couldn't do. Now you put it that way, maybe I did hit the car. Simple is good. A postcard. While I was in law school, I worked in a state AG office, Administrative Appeals Division. Guy was appealing a huge tax bill for unpaid tax on his dairy farm's milk production. His entire defense and claimed basis for appeal was that he had zero notice of the requirements to report production, sale and proceeds. In initial disclosures, pile of discovery was a postcard from the state tax office from when he initially registered to obtain a state tax number. Very smart AAG laid low. Sprung it on the guy after he has cemented his position 50 ways to Sunday. Exploded his whole theory, resulting in big judgment. Moral: read your own discovery responses and document production before building your entire theory of the case. One piece of paper can kill your client's position. This lesson has saved my bacon in 27 years of practice for sure. Not a lawyer, but going to law school. I worked for a defense attorney who did a lot of federal work. One of our cases was with this guy charged with sex trafficking of minors. We met him at the prison to interview him and he swore up and down he had nothing to do with this and that he didn't even know the girls. A month or so later, heaps of evidence from the US Attorney's Office comes in and it's pages of Snapchat messages and texts between him and these girls. Video confessions from every co-defendant and victim saying our guy was the ringleader. Proof of him checking in out of different motel rooms, etc. We showed him the evidence and he claimed his co-defendants were conspiring against him. He continued to deny everything and wanted to go to trial, but we repeatedly told him that would not be wise because of all the evidence against him. He ended up requesting a new attorney to be appointed, claiming that we were ineffective. To this day my old boss and I reminisce about how difficult this client was when we catch up on the phone. Not mine, but saw it in our entertained parents. The case was about a woman who took the car from her daughter and grounded her. The daughter called the police and the court proceedings began. Apparently the woman didn't tell her lawyer that the daughter was 22 years old and didn't live with her mom. The mom decided to go to the daughter's place and took her car out without her knowledge. I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets, and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on contingency once he obtained the verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.5 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200K because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates got $8K apiece for 2 years of work. Not mine, but went to court over a ticket. Lady was in front of me for DUI and hit and run. The judge assigns a lawyer for her since she was so shook she quit her job. The judge asked the prosecuting attorney for details on the case. She legit says, "You mean that car I hit while I was intoxicated?" The judge stops, takes his glasses off and says, "Everything is recorded in this courtroom. I told you not to talk to anyone about your case except the attorney that I assigned for you." You could tell he was ready to walk out of the room with the level of stupidity this lady showed. He sent a photo of his wife's beaten face to his wife with a message saying something along the lines of this: "Do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. Opposing counsel: "Isn't it true you hit victim in the face with a brick?" Client: "No, Marcus hit him with a brick. I hit him in the back with a piece of wood." When I was a law student, I interned for a judge. One of the cases we were observing was an illegal lockout case, where this owner of a franchise location for an international cafe company claimed the landlord owner of the right to issue franchises in the US happened to be same guy. Just one day locked him. Franchise owner out. Landlord had claimed the franchise owner was selling unapproved merchandise with the company's logo on it. For 2 days all we're hearing is about these cups the plaintiff allegedly made. Argument was that counterfeit merch violated terms of franchise and lease, which meant terminating both. Finally, the landlord is on the stand. The defense attorney pulls out a shopping bag as he's about to introduce evidence. Me and the other interns are so excited. For 2 days we've been hearing about these ducking cups, and the landlord suddenly can't remember where he got the cups from. In response to one question he says he got them at the cafe. In another he says the corporate office gave it to him. Since he raised doubt about the source of the cups, the judge wouldn't let them in, and we never got to see them. The defense attorney had to sadly put the bag away back into his briefcase. So yeah, lesson learned. Prepare your ducking witnesses, especially when you're trying to introduce critical evidence.